Hello and good afternoon. Happy Tuesday. Hope everyone had a great Memorial Day weekend if you're in the United States. And I would like to welcome everyone to today's webinar, COVID-19's impact on Canadian immigration. We have a great presentation ahead of us, but before we get there, as always, I want to go over a few housekeeping items. Today's broadcast will be about 45 minutes long, and that includes an audience Q&A at the end. So we highly encourage you to ask some questions if you have them. To do so, please type your question in via the GoToWebinar question box that you should see on your screen, and we'll try to answer the questions at the end of the main presentation. Additionally, this webinar is being recorded, and you will receive a link to download the recording tomorrow afternoon. You will also receive a link to download the slide deck, as well as the SHRM and HRCI continuing education credits. All of those materials will arrive in your email inboxes tomorrow afternoon, so please keep an eye out for that message. And if for whatever reason you don't receive it, just let us know and we'll be sure to send it your way. Additionally, while we are not anticipating any hiccups, if you do come into any audio or visual difficulties, please excuse those. We are all still remote, as I'm sure most of our attendees are. Again, we are not anticipating anything. I just want to let everyone be aware of that. So just talk a little bit about Envoy. For nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 150 countries, has grown 37% year over year, and works with over 1,000 customers. Envoy is particularly proud of their NPS score, and that's a testament to the employee experience that we provide. And introducing today's main presenter, joining us is Jim Yang, a senior global mobility specialist at Envoy. Jim is a licensed Canadian immigration practitioner and is a subject matter expert on Canadian immigration policies and procedures. He has over 6 years of corporate immigration experience across several industries, such as oil and gas, transportation, technology, and many more. Jim provides comprehensive policy consulting, case strategy, and compliance advice for Canadian immigration, and has project experience with immigration process optimization. And prior to joining Envoy, Jim worked in multinational immigration firms where he was responsible for managing the delivery of business immigration services for corporate accounts and consulted on all sorts of Canadian immigration matters, ranging from work permits, visas, LMIAs, and permanent residency. Jim, thank you so much for joining us this afternoon.
Thank you, Eric. Happy to be here.
Awesome. So with that, we're going to move into the presentation. First, we do have a couple of disclaimer slides. COVID-19 is a rapidly evolving situation in the U.S. and around the world. As always, please be sure to check official government websites for the latest updates. And before making any types of international travel arrangements, and as always, be sure to consult with your immigration and legal teams. And these are the latest numbers regarding the COVID-19 pandemic, about over 5.5 million cases worldwide as of about an hour ago. These come from Johns Hopkins University. And then I'm going to turn things over to Jim after one final legal disclaimer slide. And with that, Jim, I'm going to turn things over to you to hear about the latest COVID-19 updates and impact on Canadian immigration.
Thank you, Eric. Thank you for the introduction. So, in today's presentation, I have grouped the material into three main topics. First, I will discuss about the travel ban orders that are currently in place and the COVID travel restrictions, such as who cannot enter into Canada and who can enter into Canada. Then I will cover some of the special immigration measures that have been implemented in response to the current environment, such as biometric and document request extensions and temporary processing changes. Lastly, I'll end off with answering some common COVID immigration questions being asked by foreign nationals and HRs. Moving on to the next slide. Diving right into our first topic, let's have a look at the prohibition of entry into Canada from the United States order, or in short, we'll call it the Canada-US order. Now, this travel ban was announced by Prime Minister Trudeau on March 18th and came into effect on March 21st. This order was set to expire initially on May 21st, but both Canada and US has recently reached another agreement to extend their border closure for another 30 days, bringing the expiry date of this travel ban to June 21st. There's been a lot of media attention saying that Trudeau will most likely want to extend this Canada-US order again in June. However, there is still a good chance that it'll end as well. So we'll need to see what will happen as we get closer to the June 21st date. At present, this Canada-US order essentially prohibits foreign nationals from entering into Canada from the United States for discretionary or optional purposes. And what this means is that foreign nationals entering into Canada from the United States for non-essential reasons such as tourism, visitation, business visitor activities will not be allowed entry. So as a result, this travel restriction applies to a vast majority of people entering from the United States. However, with that being said, there are a handful of exemptions to this travel restriction. And before I forget as well, this order also does not apply to Canadian citizens and permanent residents, meaning that they are still allowed to enter into Canada if they are residing or entering from the US. Now, with the Canada-US order, there are no list of specifically exempt individuals, unlike the international order, in which we'll look at later on. But this order does incorporate by reference the list of individuals exempt from the general prohibition on travel contained in the international order. And as a result, people indicated on that international exempt list will also be allowed entry from the United States. Now, some exemptions include holders of Canadian work permits or study permits, immediate family members of a Canadian citizen or permanent resident. And what immediate family members include are, for example, spouse, a child or a parent of a Canadian citizen or permanent resident. Passengers transiting through Canada are also exempt, as well as providers of emergency services such as medical professionals. Also exempt from the travel restriction are temporary foreign workers. However, this one's a bit more complex and tricky. Now, when I say temporary foreign workers, I'm referring to people that have been approved for a work permit but have not yet activated at the port of entry, or visa-exempt nationals from the US who are eligible to apply for a work permit at the border. Now, while IRCC has announced that temporary foreign workers are allowed entry, the reality is that you still need to demonstrate your entry to Canada is for essential and non-discretionary purpose. And this is at the discretion of the CBSA officer at the border. What this means is that even though you qualify for a work permit, the CBSA officer that is stationed at the port of entry will need to be satisfied that your entry is essential. And it is very important to note that there is no magic formula to this. There are some things that will help, in the adjudication of your entry, such as a letter from your Canadian employer, being employed in a critical industry and working in a role that the officer views as essential will definitely help. Since it is up to the CBSA officer's judgment to determine if your entry is optional or not, there is no, set of special documents or script that will guarantee you would be allowed to enter. Therefore, I highly recommend if you have a temporary foreign worker that is looking to travel into Canada from the United States at this time, check with your immigration provider and get their advice on this situation. While it might be possible for them to enter, there are risks of being denied entry. So unless it is absolutely urgent or essential for them to travel to Canada, it might be best for the employee to not attempt entering into Canada at this period and wait until the border restrictions are lifted. If we can move on to the next slide, Eric, let's have a look at the Canada travel ban order currently in place for all other countries. Now, the prohibition of entry into Canada from any country other than the United States order, or in short, the international order, is very similar to the US version. The biggest difference is that this travel ban applies to all other countries besides the United States and contains the exemption list I previously mentioned. This order is meant to prohibit foreign nationals from entering into Canada for discretionary purposes from every other country besides the United States, and it remains in effect until June 30th as of right now, with the possibility of it being renewed closer to the end of June. As referenced in the Canada-US order, the exemption list for entry into Canada comes from this order and includes work permit and study permit holders, immediate family members of Canadian citizens and permanent residents, and providers of emergency services. I won't go into too much detail with all the other exemptions, but some other examples include permanent residents, people that have been approved for permanent residence before March 18th, flight crew members, individuals who have authorization from the Canadian consulate, and licensed healthcare professionals invited by the government to assist with the COVID response. Those are a few examples. Now, with respect to temporary foreign workers, it is the same as the Canada-US order with one major difference. People that have been approved for a work permit and have the approval letter still needs to demonstrate to the CBSA officer that their entry into Canada is essential and non-discretionary. Where the difference comes in is for people that are visa exempt and can apply for the Canadian for a work permit at the Canadian border. So unlike the Canada and US order, where it is still possible for a foreign national coming from the US to apply for a work permit at the border, even though it is up to the discretion of the officer, IRCC has now announced that no work permit applications will be adjudicated at the port of entry for temporary foreign workers coming from any other country besides the United States, even if they are visa exempt. So, for example, a UK citizen coming from London prior to the order is eligible to apply for a intra-company transfer work permit at the border if they have an application package ready. Now, with this order in place, they are no longer eligible to do so, even if their work is considered essential. They will need to go through consular processing in order to apply for the work permit. One thing to keep in mind is that even though you might qualify to enter into Canada under an exemption, you must have the appropriate documents to prove that you meet the criteria, and I highly recommend speaking to a Canadian immigration lawyer or consultant prior to making any plans to ensure the chances of entry are high. Now, because of the heightened security at the Canadian borders in response to the COVID environment, many of our government sources have confirmed that border officers will not hesitate to deny entry if they feel that your request to enter is not necessary at this time. So I definitely recommend connecting with either your immigration provider or Envoy just as a precaution before having your employees travel to Canada during this time if it's absolutely necessary that they need to enter. If we can move on to the next slide, Eric, let's discuss about the mandatory isolation order. Now, on March 25th, the Canadian government implemented the mandatory isolation order to minimize the introduction and spread of the coronavirus. Now, this order essentially requires all individuals who enter into Canada to isolate for 14 days from the date of entry. So if you're exempt from the travel restrictions, you must have an isolation plan to quarantine for at least 14 days when you arrive in Canada. And this is mandatory for everyone, even if you show no symptoms. Now, as part of the plan, you should explain how you intend to quarantine for 14 days. For example, how do you plan to get food and where do you plan to stay? These should be elements incorporated in your isolation plan. Now, if you do not have an isolation plan in place, you would either be denied entry or made to isolate at a government designated hotel for the isolation period. It is also a requirement that you wear a mask during your travel from the port of entry to your isolation location. This is a strict requirement. Now, if you don't have a mask, one will actually be provided to you by the officer, the border or health officer at the port of entry. Now, IRCC has also confirmed that for temporary foreign workers, their Canadian employer must also not be subject to mandatory disclosure, and that they will be able to start their employment after the 14-day isolation period. So if your Canadian employer is not able to reopen due to provincial or federal regulations, it is important to note that you should not proceed to Canada. Now, because of the seriousness of the coronavirus and for the protection of everyone in Canada, the Canadian government has made it very clear that failure to comply with this order is considered a criminal offense under the Quarantine Act. The penalties for non-compliance can include a fine of up to $750,000, 6 months of jail time, also being found inadmissible into Canada as a temporary or permanent resident, and or being banned from future entries into Canada as well. Now, while the order does allow for some minor exemptions from the requirement to self-isolate, these exemptions are targeted for very specific people, such as flight crew members, individuals invited by the Minister of Health, emergency or medical service providers, and essential workers critical to preserving life, health, and basic societal functions. So for the over 95% of people coming into Canada, you must have an isolation plan to quarantine for at least 14 days, even if you're a Canadian citizen or permanent resident. I would say that while all orders are being taken very seriously by the Canadian government at this time, this one is definitely at the forefront, and a lot of measures are being put into place to ensure compliance with this requirement. As we move on to the next slide, let's get into our second topic of special immigration measures currently in place. Eric, if we can move on to the next slide.
The instructions?
Yes. Sorry. Yeah, that's correct. Yeah. So on April, thank you, Eric. Sorry about that. So on April 9th, the Canadian Minister of Citizenship and Immigration issued out formal instructions which temporarily suspended the processing of most applications for visitor visas, also known as temporary resident visas and electronic travel authorizations. Now, unless the TRVs and ETA applications pertain to foreign nationals who are not prohibited from entering into Canada, meaning that they are exempt from the travel ban implemented under the Canada-US order and the international order, IRCC will not be processing them as long as this MI is in effect. So this ministerial instructions, these instructions are intended to limit the spread of the coronavirus in Canada and temporarily restrict the entry of non-essential individuals at the moment for public safety. As of right now, the suspension will last until June 9th, but the chances of it being extended are definitely high as both the travel ban orders are still in place. Now, to further go into the details of these MIs, it states that all TRV applications for visitors, and it is important to remember that these also include business visitors as well, which were received before or after April 9th, will not be processed. And furthermore, it also indicates that ETA applications that require processing when these MIs are in effect will also be suspended. Now, this means that if you have a TRV or an ETA application that is currently pending, it will not be adjudicated until this suspension has been lifted. This does not mean, however, that your application will automatically be withdrawn. So as these MIs are temporary in nature, all applications that have already been filed and accepted by IRCC will be retained. Now, if you're eligible to travel to Canada at this time under an exemption and require your TRV or ETA to be processed, you would need to either email IRCC and advise them that you are exempt, advise them why you're exempt, and how your travel is essential and non-discretionary, as well as your application reference details. Upon review, IRCC will then determine if they will continue the processing of your application. We can move on to the next slide, Eric. Let's have a look at some extension times that are being granted by IRCC to temporary and permanent resident applicants to accommodate the current COVID restrictions. Now, as many of you may know, for almost all Canadian immigration applications, once they are filed, generally speaking, it is a requirement for the applicant to complete biometrics unless the individuals have completed them before on a prior application. So unless if they've completed it before, it's going to be almost for most cases they're going to need to complete biometrics. For temporary resident applications such as work permits, study permits, or visitor visas, once you have given your biometrics, they are valid for 10 years and can be used again for extension applications or other temporary residency applications. Now, IRCC will typically issue out the requests, or also known as the biometric instruction letter, to applicants once their work permit, for example, is filed. Now, this request is sent out usually within 1 to 3 business days upon application submission, and it allows the applicant 30 days to provide their fingerprinting and photograph at a collection site nearest to them. Failure to provide biometrics within the allotted time can lead to a refusal, and as a result, it is often very important to complete them as soon as possible. Now, since IRCC has recognized that many biometric collection sites are still closed, such as visa application centers, ASCs in the United States, and Service Canada offices, they have automatically extended all biometric deadlines. And what this means is that individuals do not need to give biometrics until the collection sites reopen. This applies to you even if your biometric instruction letter says you have 30 days to complete your fingerprinting and photograph. Now, since this is automatic, people do not have to contact IRCC for this extension, and no new biometric request letter will be needed to make an appointment when sites do reopen. In addition, IRCC has announced that all immigration applications will not be refused or closed out if you cannot complete your biometrics due to COVID site closures. As of right now, some biometric collection centers in the United States have plans to reopen on or after June 4th. So definitely keep an eye out for that if you have employees that need to complete biometrics as part of their application process. Now, another special measure being put into place in light of the restrictive COVID situation is that IRCC will now give additional time for applicants to submit supporting documents for their PR application as well. What this means is that if you're unable to submit documents such as police certificates or complete your immigration medical exam for PR applications, IRCC will now allow you 90 days to complete these steps. Moving on to the next slide, let's talk about processing times for applications. Now, due to the ongoing situation with COVID, most IRCC offices, whether they're overseas or in Canada, are currently operating at a reduced level. Now, IRCC has announced they are working on processing applications as quickly as possible. However, processing times are being affected, and any disruption caused by COVID is not reflected accurately on their website, meaning that the processing times indicated on the IRCC website is no longer accurate. The good news is that IRCC is still accepting most immigration applications, such as work permits, study permits, extension applications, and permanent residency applications. But definitely do expect that these applications will take longer than usual to process. In addition, LMIAs are still being processed by Service Canada, but similar to IRCC, they are also going to take longer to process than their normal 3 months, since the agency is operating at a reduced level as well. Now, before we move into our final topic of common questions, I want to take a little bit of time to talk about employer compliance as well. And what I mean by that is, for example, if you have an employee who has a Canadian work permit that allows them to work in Toronto, let's say, but because of COVID, he is working remotely in Vancouver, because he wants to be in the same city with his family. You as the employer may need to file a change of conditions application for compliance purposes if the employee's work permit is location specific or does not allow authorization of work in multiple locations. Another consideration to keep in mind as well is that if your company is considering layoffs, a reduction in assigned work hours, or adjustment in salary due to the coronavirus, you may also need to report these changes to IRCC or Service Canada, depending if your foreign workers are on an LMIA work permit or an IMP work permit. So I definitely recommend speaking to your immigration provider or Envoy first before allowing for these changes, as you do not want there to be any non-compliance issues with your business on the immigration front. We can move on to the next slide, Eric. Let's go over some common questions being asked by foreign nationals and HRs.
Yeah. Awesome, Jim. So we'll start with first one, question number one. I hold a valid work permit, but am not currently in Canada. Am I allowed to re-enter?
Yes. So this is a very common question that we've been receiving lately, and also been asked on a lot of forums. So the answer is yes. In accordance to the official guidelines published by IRCC, if you have a valid Canadian work permit, you may still enter into Canada as long as you meet the other requirements, such as having an isolation plan in place for the 14-day quarantine.
Great. Second common question. I am inside Canada. My work permit is about to expire and I am unable to return back to my home country. What should I do?
Now, to avoid incurring unlawful time in the country, definitely see if there's options to extend your work permit well before the expiry date hits. If there's no option to extend your work permit or switch to a different type of work authorization, then you must file what's called a change of conditions before your work permit expires to switch yourself from work status to visitor status so that you can remain in Canada lawfully if there's difficulties returning back home. While you might lose out on your ability to work, the good news is that you remain compliant and it will not negatively impact your future work permit applications, for example, with IRCC. It is important to remember that even with the COVID situation happening right now, immigration compliance still remains a high priority for the government, and it is the responsibility of foreign nationals and employers to ensure that proper status and work authorization is maintained.
All right. Is Canada still processing immigration applications?
Yes, so the answer is yes. So as previously mentioned in our last slide, IRCC is still processing work permit applications. For example, work permit applications, extension applications, and permanent residency applications, with the exemption of TRVs and ETAs that are currently suspended. With respect to express entry draws for PR invitation, they are still happening, but IRCC has confirmed that they are currently being restricted to candidates in the provincial nominee program category and the Canadian experience class category.
Moving on to the fourth common question. I recently lost my job but found a new position. However, my work permit is employer specific. What should I do?
So that's a great question. Now, with many temporary foreign workers losing their job in Canada due to the coronavirus, the government has created an interim policy that will allow foreign workers who are already in Canada with employer-specific work permits to more quickly change employers once a new work permit application has been filed. So in normal circumstances, a temporary foreign worker who finds a new job would have to apply for a new work permit and wait until a decision is made on the new application before they can start the position. This process usually takes about 90 days or more. What IRCC has done in the meantime is created this interim system, which will allow a worker to start the position with their new employer before their work permit application or their new work permit application is adjudicated. To be eligible for this, the new employer still needs to file for a work permit application for the employee under a program that they qualify for. But instead of waiting for the 90 plus days for the application to be processed, you can send IRCC a request to have the employee start in that position immediately while the application is pending. Our sources have confirmed that these requests will be reviewed within 10 days, and if approved, authorization for work to start their new job will be sent to them by email. The key point to remember is that with this new policy, only speeds up the time to start a new job. It still requires you to file for a new work permit application.
Moving on to the fifth question. My application for permanent residence has been approved and I received my COPR. Can I still travel into Canada to activate my status?
Yeah, so another great question. So the answer depends on whether you received your COPR or your confirmation of, depends on when you received your COPR and your confirmation of permanent residence. If your COPR was issued before March 18th and you have not yet traveled to Canada to complete your landing process, then you're still eligible to come into Canada as long as you have an isolation plan. If your COPR was issued after March 18th, then you will not be able to enter into Canada until the travel ban is lifted.
All right, and the final common question that we have, with the H-1B cap lottery over in the U.S., is Canada still a potential option for individuals not selected in the lottery?
Yeah, another great question. My personal answer for this one, I think it still remains as a yes, as most immigration programs in Canada remain open and our applications are still being accepted. However, do expect a delay in processing, and be sure to consult, with your immigration providers to review the options available for the worker.
Great. Awesome. Well, Jim, thank you so much for the presentation and discussing the COVID-19's impact on Canadian immigration and going over some of those common questions. Now we're going to open the floor up to audience questions, and give me 1 second here. Okay, so as always, we can only really answer general questions. So a couple of these questions I need to run by Jim. I'm going to run them by you to ensure that they are okay to answer over the air. So I'm going to chat them to you via Teams. To
For
our
sure.
attendees, please excuse our awkward silences right now as we discuss the questions.
Yes. So I think, Eric, we can definitely go over the question that you sent over here with respect to the
Okay.
LMIAs. Mm-hmm.
All right, great. So Jim, this question is, how have LMIAs been impacted since COVID-19? And then the second part to that question is, has the labor market been greatly impacted that will impact our LMIA?
Yes. So per our presentation, LMIAs are still being accepted by Service Canada. There are going to be delays in the processing of LMIAs. Based on our sources, a lot of the officers that are working in Service Canada are saying, for example, under the global talent stream, it usually takes them about 2 weeks time to process, a GTS application. They are taking, a significantly more amount of time to process something that usually would take them about, 2 weeks time. I would say with respect to the labor market, I mean, there are no exemptions under because of the COVID situation. So, employers are still required to advertise for the role if they're going under the regular LMIA stream category for low and high wages. But if you're under the global talent stream, all the requirements still remain the same.
Great, thank you. And Jim, I chatted you another question.
Mm-hmm. Just gonna quickly review the other questions here. Yes, so we can definitely go over the second question here. Eric, you can ask the question and then I can provide the response. Yeah.
For sure. So does the travel restrictions apply to the citizenship of the traveler only, or the country where the traveler is coming from? For example, a UK citizen who resides in the US that needs to enter Canada.
Yeah, so that's a great question. So in this scenario, the UK citizen will be impacted by the Canada-US order instead of the international order. If your purpose in entering to Canada, falls under the exemption and is of, essential and non-discretionary purposes, you're definitely still eligible to enter into Canada. But do keep in mind that you will need to, advise the CBSA officer and present evidence of your isolation plan, and there will be that need of the 14-day quarantine requirement.
Great. And speaking of that 14-day quarantine requirement, Jim, I just sent you another question on that particular subject.
Yes. So right now, isn't indication of when this mandatory isolation order will be lifted. For example, the Canada-U.S. order is expected to be is expected to expire on June 21st, but and also for the international order, it's expected to remain in effect until June 30th. But with a lot of these orders, there is a very high possibility of them being extended. With respect to the mandatory isolation order, there hasn't, or at least to my knowledge, I don't believe there's an expiration date.
Okay, great. Thank you. And Jim, I think we're gonna end things there. Last of the questions that we can answer. There are a couple more that are a little too specific and we cannot answer over the air live. So if we didn't address your question, please speak with your immigration attorney. So Jim, thank you so much for the presentation today. To our attendees, thank you so much for joining us this afternoon. As a final reminder, this recording and the slide deck and the SHRM and HRCI continuing education credits will be emailed out tomorrow afternoon. So please keep an eye out for that message. And if you don't receive it, please let us know and we'll send it your way. So again, thank you so much for joining us and have a great rest of your afternoon.